Good afternoon. Thank you for joining us. I hope everyone is enjoying the annual conference so far. My name is Laura Robertson, and I am chair of the Institute of Energy Law. And I am pleased to welcome you to the Dean's Oil and Gas Lecture. As you may know, each year during the annual Oil and Gas Law Conference, the Institute of Energy Law invites a distinguished legal practitioner or academic to present the Dean's Lecture, which is an opportunity for him or her to reflect upon a career in oil and gas law. The lecture has been given by many longtime legal scholars in the energy industry, such as Professor Jacqueline Weaver, Professor John Lowe, as well as Congressman Joe Barton and Charles Matthews, the former General Counsel of ExxonMobil. When selecting this year's lecturer, the executive committee naturally thought of Reagan Simpson, who has an excellent reputation for handling a wide range of energy disputes. He is known for his encyclopedic knowledge of oil and gas law, as well as for his outstanding advocacy skills. I will now turn it over to Tracy Leroy, Reagan's law partner, for a few additional introductory remarks. Thank you.
It is my privilege to introduce my partner, Reagan Simpson, who will give the 2021 IEL Deans of Oil and Gas Lecture. My name is Tracy Leroy, and he and I are litigators at Yetter Coleman, a firm that focuses on high-stakes business litigation for plaintiffs and defendants in the energy, technology, and financial services industries. Reagan's accomplishments are lengthy. The pride of Jacksboro, Texas, Reagan was at the top of his class at the University of Texas Law School and clerked on the U.S. Court of Appeals for the Fifth Circuit. He then excelled as a litigator. Reagan is the proverbial triple threat, a fellow of the American College of Trial Lawyers and the American Academy of Appellate Lawyers, plus a member of the American Law Institute. Reagan was named Houston Appellate Lawyer of the Year twice and Austin Appellate Lawyer of the Year by Best Lawyers in America. Just last year, he was honored by the Texas Center for Legal Ethics with the Chief Justice Jack Pope Professionalism Award, and also by the Texas Bar Foundation with the Gregory Coleman Outstanding Appellate Lawyer Award. Reagan is one of our state's very best litigators. Reagan is the ideal choice for the Dean's Award and to lecture to this group. First, he has been personally involved as an advocate in some of the most significant decisions affecting the energy business. He has handled, at trial or on appeal, every sort of oil and gas case imaginable, from refinery explosions to releases, oil field accidents to pipeline leaks, trade secret theft on drilling equipment to royalty and mineral interest disputes, indemnity agreements to coverage disputes between owners and operators. I cannot name a type of dispute in the energy industry that he has not handled and, most likely, solved. Second, and more than any other lawyer of his prominence that I know, Reagan truly delights in the law. He loves to talk about and explain why cases were decided a certain way. In fact, this happened just last week. We have a new oil and gas case with a damages cap issue, and I asked Reagan if he could explain the governing Texas Supreme Court case to me. Not only did I get a response from him in mere hours, he had already sent me a law review article right on point and had reached out to the author to see if it had been updated. He then made time to talk through the issue with me late on Friday afternoon. Reagan simply loves the law. In nominating Reagan for the Coleman Award, former Justice Harvey Brown described him as the type of lawyer that judges look forward to seeing in their courts. What Justice Brown is describing is why my colleagues take any excuse to wander by Reagan's office on any given day just to talk about our cases. Reagan always shares his knowledge about the law generously. He always is accurate, and he draws the bigger picture for you. I'm confident you will learn from him today and enjoy the lesson. Reagan is a true lawyer's lawyer. Please join me in welcoming this year's IEL Dean's Award honoree, Reagan Simpson.
Thank you, Laura, and thank you, Tracy, for those very kind words of introduction. And let me express my gratitude to the Institute for this award. It was very unexpected. When I looked through the list of past recipients, I felt undeserving. I cannot match the depth of knowledge of oil and gas law of many past recipients like Ernest Smith, the dean of my law school when I was at the University of Texas. Nor can I match the experience in this industry of my friend Charles Matthews. Instead, what I draw upon is my career spanning over 40 years of representing members of this industry in many different types of arenas and disputes and cases, some big, some small. As I reflected upon my career, I developed a thesis, and that's the basis for my lecture today, and also a paper I prepared that provides this thesis in a little more depth with case citations. My thesis is about the development of the law. You know, lawyers and judges are important to the development of the law, but clients are essential. And my thesis is that the energy industry should be credited with the development of major areas of Texas law for the benefit not only of the industry, but of other industries and for individuals in their everyday work and lives. Let me now review my career with that thesis in mind. And I'll go back to nearly the beginning. I remember being in Matagorda County, then a hotbed of litigation, arguing against an indemnity for a drilling contractor against a major oil company. We won. I called the contractor. The representative said he was not happy. He said, "You don't understand. I wanted to honor the indemnity. I get most of my business from this oil company." I said, "Well, the insurance company is not going to honor the indemnity if it doesn't apply." That was my introduction to the tripartite relationship among drilling contractors, operators, and insurance companies. Little did I know that about 40 years later, that same relationship would be at issue in the largest appeal of my career. In Deepwater Horizon before the Texas Supreme Court, the issue was $750 million of insurance coverage for Transocean. This time, the contractor didn't want to cede its coverage, and neither did the insurance companies. We prevailed in that case, and I remember distinctly the celebration dinner afterwards with the Transocean General Counsel and others, and they put me at the head of the table, and I demurred. I said, "You know, this was a group effort. A lot of talented lawyers and people participated in this." And Steve Roberts, my former partner, said, "Reagan, you don't understand. If we had lost, it had been all your fault. And so you get to sit at the head of the table." And maybe that's why just before argument, my opposing counsel came up to me and whispered, "Reagan, do you think we can settle this case?" In Deepwater Horizon, the Texas Supreme Court departed from the four corners rule of interpreting policies and looked to the drilling contract because the policy referred to the drilling contract. That was what we argued. I argued a little bit broader policy basis, though. I argued that when an insurance policy arises from a contractual relationship, you ought to try to interpret the policy, if you can, consistent with the contract. Because I had seen many times in my career when policies just simply did not match contracts. Instead, Texas has generally had the reflexive rule that if there is any possibly reasonable interpretation of a policy that affords coverage, adopt that interpretation. And that interpretation can be adverse to what the parties really agreed. So that policy argument was not adopted in full force, but the holding was consistent with it. Of course, long before Deepwater Horizon, there were a lot of issues percolating around about indemnity and insurance. A fuel additives company called Ethel Corporation gave us the express negligence rule. I remember when that case came out. It greatly simplified the issue of whether indemnities are or are not enforceable. And it benefited industries and people throughout the state. As a result, indemnities were enforced. And the Texas legislature got concerned about inequities in the oil patch, so they passed the Texas Oilfield Anti-Indemnity Act to limit the scope of indemnities. I remember that in the hearings leading up to that act, my firm then, Fulbright and Jaworski, engaged in a rare instance of lobbying. Our client, Red Adair, wanted to have a wild well exception. So he testified in support of that exception. Now, Red Adair was a pudgy, red-haired man with a ruddy complexion who maybe was 5 foot 5 inches with his boots on. After he testified, the first comment from the legislature was, "Mr. Adair, you don't look like the actor who portrayed you in Hellfighters." That actor was John Wayne. So Red Adair did not have the physical stature of John Wayne, but he had stature otherwise, and he got his wild well exception. The Ethel Rule and the Anti-Indemnity Act led to a focus on additional insured provisions. And it was Getty Oil that brought us the decision that additional insured provisions can be separate from indemnities. Not true at all jurisdictions, and that has been to the benefit of many industries and individuals. Another big issue in Texas law has been the concept of control as a basis for tort liability. That all began with two important cases, Shell Oil versus Lamb and Obelos versus Oil Development Company of Texas, both holding that an owner was not generally responsible for an injury to a contractor because, after all, contractors were supposed to know how to do their work safely. But that changed in the 1980s. The headline case for that change could have been Tovar versus Amarillo Oil, which was argued at the same time as the headline case, Redinger. They both came down within days of each other, and the court expanded the concept of control so that an exercise of control or a contractual right of control could impose liability on an owner, general contractor, or operator. That went a little too far for the Texas legislature. After some clarification of that law in Exxon Court versus Tidwell, for example, and most notably in the Olivo case, Clayton W. Williams Jr. Inc. versus Olivo, which I cited many times. In that case, the court clarified exactly what the control test was and differentiated negligent activity and premises liability in the oil field context. But that clarification went too far for the legislature, so they adopted Chapter 95 of the Civil Practice Remedies Code, which limited the type of control that would create liability and also required actual knowledge of the injury causing risk by the owner, general contractor, or operator. And it was a petrochemical case that decided that Chapter 95 applied only when the contractor was injured working on the improvement in question, which was a surprising result to me. And in fact, that has been somewhat problematic in drilling rig accidents because the improvement at a well site is the well, not associated equipment, and maybe not even the rig. So that area is still in flux and still developing. Another area of the law that is developing involving the energy industry is trespass. Trespass is an archaic tort. It doesn't fit very well in our modern scheme of law. Recently, the Texas Supreme Court in Lightning Oil versus Anadarko held that there was no liability for trespass, even though a trespass occurred and even though there was some subsurface injury. That's a novel concept in trespass. And pending now before the Texas Supreme Court is a case that raises the issue of when a cause of action for subterranean trespass accrues, and the actual issue for decision in that case is when limitations accrues, when there is a claim of current increase in drilling costs because of a threat of subsurface migration. I predict that there will be even further developments in trespass law credited to this industry in cases involving such things as climate change. The law is unsettled on what type of fault, if any, is needed for trespass, or how much awareness of the likelihood of trespass is required, and how do you apportion responsibility when human conduct combines with a natural disaster. the act of God defense does not fit well in our current regime of law. The restatement third suggests causation apportionment followed by responsibility apportionment. Who knows what will happen, but the energy industry will be front and center in the development of trespass law. Other tort issues have been developed through this industry. I handled a case for Neighbors Drilling that held that a company is not obligated to warn its employees not to drive while fatigued because it's common knowledge. I think that principle will be very important if the Texas Supreme Court ever gets around to discussing the scope and elements of negligent hiring, training, and supervision. Another Neighbors case held that evidence of non-use of seatbelts could come in at a trial because a proportionate responsibility statute should include both injury causing conduct and occurrence causing conduct, a principle that has had a lot of effects in other industries. The proportionate responsibility statute was important in the case that I handled for ConocoPhillips. In fact, it changed substantive law. ConocoPhillips was sued for conversion of oil belonging to the Republic of Mexico, which had been stolen by cartels and then resold across the border. Some of it allegedly got into a refinery of ConocoPhillips. Well, conversion is an archaic tort like trespass. At common law, there was no defense for innocence or good faith. But conversion is a tort, and the Proportionate Responsibility Act applies to all torts. So that meant that at trial, the jury would apportion responsibility among the defendants and members of the cartels. That seemed to dampen the enthusiasm for that case by the other side, and we won outright on other grounds. I also remember handling a refinery explosion case in Corpus Christi, and we dealt with novel issues of negligent entrustment and negligent budgeting. We won the case on appeal. But oddly enough, the largest explosion case that I worked on, the 1989 explosion of the Houston Chemical Complex, did not lead to any big legal issues. I handled that case at the same time I was working on a massive case that resulted from an HF acid leak at the Marathon refinery. These two cases took up at least 10 years of my life. But the fact is, we didn't appeal any of those decisions because we were satisfied with the results. The other side appealed, and that sort of supports my hypothesis, or my thesis, that it is the energy industry bringing forth issues that has caused major developments in the law. Another big issue in Texas law affected by this industry is exemplary damages. When I first started practicing law, almost no one alleged gross negligence. You couldn't prove it because all the defendant had to do was show some care. You could almost always show some care. But Burke Royalty versus Walls abolished the some care test and ushered in a decade of frequent allegations and frequent findings of gross negligence. That led the Supreme Court to redefine gross negligence in a much more restrictive way in Transportation Insurance versus Morial, and that opinion starts with a long discussion of Burke Royalty. And then that redefinition became part of and spawned Chapter 41 of the Texas Civil Practice and Remedies Code, which is an extensive statutory regime that limits the incidence and size of exemplary damages awards. As a result, affirmances of gross negligence on appeal is rare, an exception being Mobil Oil versus Ellender. A more typical result is a case I handled called Diamond Shamrock versus Hall, where they found no gross negligence, but also sidestepped the thorny issue of how to calculate the cap in employee death cases. In Hall, the other side raised the constitutionality of the cap on exemplary damages, an argument that went nowhere. But largely, the other arguments on the other side went nowhere too. I spent a lot of time working with a major oil company developing defensive constitutional arguments against exemplary damages in a civil case. And we raised some of those issues in the Houston Chemical Complex case, but they never got traction. The most that those arguments ended up causing is an increase in the strength of jury instructions for guidance to the juries and increased appellate review of exemplary damages award, with the exception of the Valdez case, which resulted in a 1-to-1 ratio cap in maritime cases, and Johnson & Johnson is now trying to extend that cap to other types of cases. And of course, you can't talk about this area of the law without mentioning Texaco versus Pennzoil. I can remember that a walkie-talkie communication in the era before cell phones signaled the need to file a bankruptcy petition because the state court judgment had just been filed that awarded damages that at that time exceeded the world bonding capacity. To prevent Texaco-type bankruptcies, Texas adopted bond reform. You don't even have to bond exemplary damages anymore. The Valdez case also led to that, as well as tobacco litigation, and you've seen that in many different states. And that has been to the benefit of many industries and many individuals who otherwise would go broke trying to challenge a large verdict on appeal. The last topic I want to talk to you about is contract law. The biggest change I've seen in contract law has happened over the last 15 or 20 years. It all started with Schlumberger, case about diamonds, not oil in that case, where the court held that a disclaimer of reliance was effective in a settlement agreement because it had been negotiated heavily with lawyers by sophisticated parties. That was a narrow holding. Justice Craig Enoch, who wrote that, thought it was narrow and was surprised at its expansion later on. And the key comes in Forest Oil, a dispute about surface damage. And Forest Oil has a footnote. It says disclaimers are effective in regular contracts as well as in settlement agreements. And I focused on that footnote in a case against an oilfield service company and upholding the disclaimer in a contract that was not negotiated with lawyers, and the disclaimer itself was not even negotiated. And that footnote in Forest Oil contributed to an explosion of cases, many involving this industry, extolling the virtues of freedom of contract, which the Texas Supreme Court has put up there as one of the top public policies in our state. A fairly remarkable statement. And that has also gone hand in glove with the economic loss rule that has been developed in Texas. It is actually stronger than any other economic loss rule in the nation. In energy cases, we're at the beginning of that. Signal Oil was a famous economic loss rule case, and I handled a case successfully on appeal called Sterling Chemical versus Texaco that was once the most cited opinion in that area. The purpose of those two developments in contract law, I think, are to allow parties to control their destiny by writing clear contracts and to take out uncertainty by removing torts from commercial disputes. We have seen that applied in the oil and gas industry. In the Carrizo oil and gas case, parties could contract against industry custom. And even more significant, in the Energy Transfer versus Enterprise Products case, the parties with a condition precedent could supplant the Texas Uniform Partnership Act, to the surprise of many academicians. Of course, sometimes you have to look at surrounding circumstances to interpret a term like offset well in the world of unconventional drilling, and we know from Burlington Resources, as the Texas Supreme Court lamented, there are still many opaquely worded oil and gas agreements. And I should mention here one point. We are in an era of freedom of contract, but you can set your remedies, the way that you resolve disputes, the limits on damages, all sorts of things by freedom of contract. Almost no provision is going to be void for public policy. But I've seen in my career, in very big cases, in very big transactions, opaquely worded contracts that stick on additional addenda or form documents that are inconsistent, and sometimes language that just doesn't make any sense. It seems to me that that is a funny way to do business, to make sure you get a deal done rather than trying to document it in a way that will be enforced predictably given the willingness of courts to apply whatever the parties agree to. So I think that's sometimes a missed opportunity. So, having reviewed my career, I think the thesis is well supported. The energy industry has been instrumental in many, many major developments of the law of Texas, and I'm sure other states, for the benefit of the industry, other industries, and many people. It has been my privilege to be a part of that, and certainly my privilege to receive this honor for whatever role I have played in the development of that legal landscape. Thank you very much.